All right. Good morning or good afternoon, everyone, depending on where you are in Australia or around the world as well. My name is Joel Comerford, and I am your Lawpath webinar host. Understanding director duties, what the law requires of you. Big topic today. And also a big thank you to all of you who are taking an hour out of your day to join us. It's great to see so many directors, business owners, and professionals who are committed to doing things the right way. Now, as always, before we get into it, how's everyone doing today? Can I get some comments in the chat? Is everyone having a good day, having a bad day? Is anything related to this topic stressing anyone out? And also, if anyone is new, go ahead and let us know so I can remind you guys of some of the offers that we have as well. Good morning, Renuka. Morning, Alan. Mark, Sylvia. Duties of life for this director. Love it. Love it. Perfect. Well, while everyone's going ahead and chucking in their comments, we'll move forward. So, um, for those of you who are new, for example, welcome. And for those of you who have been here before, I can see a lot of familiar faces. Always a pleasure to have you back. At Lawpath, our mission is simple: to make legal and accounting support smarter, simpler, and more affordable for small to medium businesses. Over the past decade, we've helped more than 600,000 clients register businesses, stay compliant, and grow with confidence. Unlike the traditional model of costly one-off legal work, our subscription-based platform gives you ongoing access to documents, advice, and experts whenever you need it. So why does today's topic matter? Being a director is a privilege, but it's also a responsibility that carries real legal weight. Every year, hundreds of directors across Australia face penalties, fines, or even personal liability for not meeting their obligations. Many of these issues come down to simple oversights, things that could have been avoided with the right guidance and tools. That's why today's session is so important. It's about arming you with the knowledge you need to avoid risks, lead confidently, and grow your business responsibly. Now, a bit of unfortunate news, but also a bit of a boon as well. We were originally going to have Mark Tui, one of our senior lawyers here, as today's speaker, but Mark was ushered away to take care of one of his Lawpath clients. So hopefully that's a good indication to you guys that we do prioritize our individual clients and we are very thorough in their needs. But on the bright side, we do have someone who is equally as good and equally as lovely and knowledgeable, Molly Hamilton, taking over for him today. So we are thrilled to have Molly. And just a bit of a disclaimer for you guys, Mark is very eager to join one of the webinars soon, and we will make sure that we can slot him into a sooner webinar so you guys can have your time with him. We do know a lot of the clients who are participating today, or attendees, I should say, are either clients of Mark's or they're looking to get his guidance. So we do apologize for that, guys, but we are going to give you all the knowledge you need in relation to director's duties today. So Molly Hamilton, one of Lawpath's highly regarded commercial lawyers, originally from New Zealand and now based in Melbourne. Molly brings a wealth of experience in startups and commercial advisory. Molly is known for her authentic, approachable style, supporting founders and directors to navigate the legal landscape and with clarity and confidence. She works closely with directors from the very first steps, advising on structuring, shareholder arrangements, and intellectual property protection, through to scaling for growth and securing investment. Her expertise extends to managing investment rounds, from term sheet negotiations through to drafting investment documents and modeling capitalization tables. She also specializes in preparing companies for investor readiness, including equity structuring and employee share option plans. And she's also a gun at trusts as well, which a lot of our clients benefit from having Molly as their representative through legal. Now, guys, what will we be covering today? Who can be a director? The legal requirements and eligibility, your core obligations under the Corporations Act of 2001, practical compliance strategies, so including how Lawpath can support you with tools like our resident director service, real world case examples where directors get it wrong and what you can learn from them, And we will also have final takeaways and a Q&A. So disclaimer for everyone who is new or have just arrived a bit late, we will upload the slides from today as well as a YouTube link to today's episode if you have to duck out early to our YouTube channel, which will also be part of an email that I send out to everyone. So slides, a breakdown of today, information on Molly and how you can get in contact with other lawyers, and partner offers and all the discounts and everything will be involved in this email. So stay tuned for that email afterwards. I will send that out to you. Don't stress, you will get it. And yeah, any burning questions you guys have throughout today, we will go ahead and save them for the Q&A so we can get through. I know not everyone has a flexible time schedule, so just wait for the end for the Q&A. Throw your questions in there. Try to keep it out of the chat because sometimes people, we may throw in responses there. So chuck it in the Q&A. And yeah, once again, thank you all so much for participating. We will go ahead and pass this over to Molly.
Wonderful. Thanks, Joel. And thanks for that lovely introduction. Thanks for joining today, everyone. And sorry I was a bit dodgy with the slides at the start, but the good news is that I am good at being a lawyer, less so at managing PowerPoints. But as Joel said, we're here to talk today about sort of everything about being a director, what the duties are and the importance of the role. I think a lot of times, when you're setting up a business, it's often fast-paced. Maybe you've got an idea, maybe you've got investors interested, maybe you're joining a company and you're excited about the opportunity to be a director. It's certainly an exciting title, but it's definitely worth the time of understanding what your duties are, what the consequences can be, and really investing the time like you are today. So thank you for joining, and I hope it's worthwhile. So we're starting with who can be a director, as there are some limitations around that, which we've listed here on this slide. So throughout this, we'll be referencing the Corporations Act and all the relevant legislation for being a director. In Australia, to be a director of a proprietary limited company, you have to be at least 18. You have to consent in writing to take on the roles and responsibilities of a director. That one is often overlooked, especially when you are setting up your own company, which, just a quick plug for Lawpath. When you're setting up a company, you get all of the company and corporation documents with the package of setting up a company, which if it's your first company, you might not understand the value and importance of those. But when you set up a company, you are required to have a set of documents such as director consent forms and resolutions that all come at that initial point. And you've got 28 days to sign those documents. And then they're for your own record keeping purposes. So with the director consent form, it's exactly what it sounds like. You're setting up a company, you're consenting to the role and responsibilities of a director. You sign that. If you become a director of a company later down the track, or you bring on a director to your company, they will also need to consent in writing. It's really important to have that, even though it might be easy to update ASIC and change who the director is. The paperwork is equally, if not more important, especially as we start to go through today the importance of the role of director and the potential liability and consequences that can happen if a director does not adhere to their duties. So making sure you've got a consent form. If anyone on the call right now is a director or has a company where they've got directors and you're concerned that you haven't followed that process, feel free to reach out to us after this webinar. Joel will share some contact details and we can have a chat and help you out there just to make sure that everything's in place that needs to be. Thirdly, if the company only has one director, that director is required to ordinarily reside in Australia. Or if there is more than one director, at least one of them must ordinarily reside in Australia. We'll talk a little bit about what that means in the next slide, but just an important to note here as well is that, and as Joel alluded to earlier, company directors in Australia are now required by law to apply for a director identification number or a DIN. It's really easy to do so. They introduced maybe a couple of years this law, and that it's basically an ID number. If you've got your MyGov set up or anything like that, it's a pretty straightforward process. If you just search director identification number on Google, it will come up. You do that with the business registry. All the instructions are there. When they first introduced it, there was a bit of a grace period for existing company directors getting registered. So maybe, for example, if you have been a director for a while, you hadn't heard of this, and there's no longer a grace period, and it is you can be fined for this. So if you are currently a director and you don't have a director's identification number, then I would prioritize after this call, searching that up and reach out to us if you've got any questions. Otherwise, keep that in the back of your mind. If you're thinking of setting up a company, before you do that, apply for your DIN, or if you're bringing on a director to your company, then asking whether they've registered for their director identification number. And that's director of any company, to be clear. So whether that's your business, whether you've set up a corporate trustee company to operate your trust, in any capacity, you need your director identification number. So in terms of the ordinarily reside, so like I said, at least one director needs to ordinarily reside in Australia. And outside of that, you can have non-Australian residents or Australian, as long as there's that one. There's a number of factors that determine if a person ordinarily resides in Australia. If you've ever had to update your tax residency, you'll understand as well that there's a lot that comes into it, and it's the same here. There's a number of things. It's not black and white, but some of the key things that you might consider is how permanently that person stays in Australia, particularly in comparison with other places they visit. So are they spending 6 months in Australia and then going on holiday across the world for 6 months, or are they spending 6 months in Australia and then 6 months in New Zealand, back and forth? That will be one of the things that are considered. Also, where the individual's ordinary life takes place. So this is things such as where you own or you lease the property, where you're paying for utilities, where your employment is, your ordinary life, all of the things that come part of that. And as well as whether you have employment arrangements. So are you a director of a company in Australia and you're employed in Sri Lanka? Are you a director in Australia and you're employed in Australia and you sometimes spend 3 months of the year going on holiday to Portugal? And keeping in mind as well that a person can be an ordinary resident of more than one country. But if you're not sure whether you're fitting within this, maybe you are a sole director of your company and you're not sure whether you meet the criteria for this, absolutely get in touch with us and we can help you sort of to determine that. But otherwise, if you're looking to set up a company in the future and maybe you've got some colleagues that are overseas or based between Australia and overseas, it's something to keep in mind. Perfect. So in terms of what the director's work involves, I might just take this moment to differentiate between a director and a shareholder, because a lot of our clients, we have a range of clients, but oftentimes, especially when I'm speaking to people that are setting up a company and it's their own business, so they're the director and the shareholder. Or I had a client the other day where there was 3 co-founders. They all run the business together. They're all directors. They're all shareholders. And they're all being paid a salary, so they're employees, an extra spice there. But oftentimes when you're in a business where each director is also a shareholder, the lines can be confused between the roles. And it's really important that we keep clarity between those roles, because a shareholder owns the business and receives the benefit of the business. The director is responsible for the day-to-day management of the business and can be held liable if they breach their director duties. So in the situation I gave where oftentimes you might be a director and shareholder of your business, like I say, the line can be blurred. But if you consider that an external investor came on or external shareholder that wasn't involved in the company, they weren't a director, maybe they were an investor, maybe it was a family member or a friend that wanted to invest in your company but weren't interested in the day-to-day management. The directors are responsible for acting on behalf of the shareholders because they are not involved. So the directors need to make decisions based on the best interest of the company and not themselves. This is also why you might see in negotiations for investment that a large investor or any investor might try and negotiate that they get a director seat so that they can have some oversight and some control and involvement on what is actually happening with the company. Completely depends on your constitution and your shareholders agreement, which we don't have time to talk about today, but if you've got any questions about those, we chat about them a lot in these webinars, or again, you can reach out to us. But largely depending on your rules of your constitution, your shareholders agreement, all in all, directors are responsible for most of the decisions. It's the day-to-day management. It's they're meeting at a board of directors to pass decisions that are involved with hiring employees on high salaries, taking out a bank loan, maybe signing a lease. And then the shareholder decisions are usually reserved to the decisions that are required at law. So they're the big ones, such as selling the company, restructuring, changing the business. So because of that, the director's role is really important. They are involved in day-to-day management. It's important to note that as well, because sometimes with the ordinary director the residing in Australia requirement, because of that, sometimes people might think maybe they're waiting for their visa, or maybe for whatever reason they aren't an Australian resident at the time of wanting to set up a company. It's easy to make the assumption that maybe I'll ask my friend or a family member to act as director just so I can get this company up and running. And then once I've got that approval, or once I'm an Australian resident, once I've got an Australian resident director, then we'll fix it up. I can see that that's an easy conclusion and an easy fix. But because of the extent of the role and the potential consequences, that can only be appropriate if the person that's acting on your behalf understands their responsibility, and likely it's clearly documented in some type of agreement. I haven't even started on the slide yet. So with that context in mind, the director's work I've touched on a couple of things that might be a director decision, but it's because of the everyday affairs that they're managing, they need to understand how the company is doing at all times, such as finding out what proposed actions are going to affect the company, especially if it's involving large amounts of money. Responsible for questioning managers and staff about aspects of the business, actively engaging in directors' meetings. Being a director is not a wet and forget situation. You need to be involved. You need to understand what's going on in the company, and you are going to be one of the people or the only person that these decisions are going past that you need to make the final call on. Also, something that directors may need to do or may be encouraged to do is get independent advice if you need more information to make an informed decision, and being aware of the financial status of the company. So in that way, you should only agree to being a director if you understand your responsibilities and are willing to carry them out. Like I mentioned, it will be largely due to it will be in accordance with your constitution and your shareholders agreement about the cadence of the directors' meetings, where they will be, who's required, how many directors are required to pass a decision. Are there certain decisions that need 100% vote? Are there certain decisions that need 50% vote? Are there some decisions that can only be made with the presence of certain directors? All of this is really important. And if you are a director of a company that perhaps you were added to a company, or you've been invited to become a director of a company, it's your personal responsibility to ensure that you have oversight of all of these items, how the company's running, access to records. If for any reason, perhaps you feel that you don't have access to these records, maybe you're being left out of decision-making processes, it's really important that you get independent advice about that, because it may be in your best interest to, well, first of all, either approach the business and deal with that, or resign as a director, because you don't want to be held liable for any decisions that are being made that you are unable to be party to or you don't have oversight of. So the note there, exactly what I'm saying, it's important that if you are told or invited to be a director, and that you won't need to do anything, or it will be a small role, perhaps they need an extra director to pass a decision. Maybe they need an extra director that ordinarily resides in Australia. It's not as simple as that, and you need to be very cautious and definitely seek independent legal advice to make sure it's appropriate for you. Perfect. And now we're going to chat a little bit more about navigating those legal obligations. So there are a number of duties and responsibilities of a director, and of course we're going through a lot of them today, but I do recommend if you are a director or are thinking of becoming a director, we also have a lot of resources on the Lawpath website, a lot of articles written as well, breaking down all of the different responsibilities, and it's something that you need to stay familiar with. So hopefully this isn't the first time that you're hearing these sort of general obligations, but if it is, don't fear. I just encourage that you spend a bit more time being very familiar with what they are and keeping them at the forefront of your mind whenever you're making decisions as a director. So the first is being honest and careful in all your dealings, making sure your company can pay its debts on time, ensuring your company keeps proper financial records, acting in the company's best interest, even if it conflicts with your personal interests. That one's really important, and we're going to go through a couple of examples of that going wrong shortly. And only using information for the good of your company and not for unfair advantage for yourself. That is in breach of your statutory and fiduciary duties. You might be thinking they sound really broad. And what does being honest and careful in all your dealings mean? That's why it's so important to stay familiar with your duties and responsibilities and stay involved in the business and always make decisions in light of these. There is countless different situations that can arise where a director is in breach of these duties. So just in any time that you are maybe not feeling right about a decision, maybe not thinking that the company can afford to bring on a new senior exec or purchase an asset, and keeping track and making sure that everyone is following due process. And again, that best interest is really important, and keeping in mind that also some duties and responsibilities can carry on after you've resigned as a director. The reason I flag that is that I imagine a lot of the people on this call today are people who are running their own businesses. But if you were to bring on a director perhaps to your business and then they thought, hang on, this idea is really good, but I think that I could adapt it and make a better version of this. If they did that while they were acting as director, they would very clearly be acting in breach of their duties. It's a conflict. They're using the company information for their own advantage. So some people like to think that, okay, I'm going to throw in the towel with this opportunity. I'm going to resign as director, and then I've got the opportunity to do so. That's not correct. There are protections in law that mean that you can't do that. And it's keeping in mind things like that it's not just an easy fix to resign. So really taking that responsibility, being very careful and taking it seriously. Another thing to consider on the note of conflicts as well is that often when I have clients come to me that are wanting to set up a new company and they are maybe part of an existing company, they're all friends, there's no worries. They've mentioned in passing that, they're setting up this side business, it's okay. That's all well and good, but because of that conflict of interest and those other duties and responsibilities, and again, depending on the rules of your constitution and your shareholders agreement, but in any case, it's going to be best that you raise that with your fellow directors and likely have a board a meeting that everyone's signing off on, saying that you did raise it. Maybe there's limitations about it, but disclosing that there's a conflict or a potential conflict and making sure that you've got the approval and that it's not against the company's best interests. In terms of company record keeping, again, your shareholders agreement and your constitution will deal with the requirements, and this is just sort of speaking at a broad level, at the bare minimum. And going back to my example as well, in terms of the shareholders that might not be directors, they might have access to certain documents as well. It may be in your shareholders agreement, they may have negotiated it or asked for it. Maybe they hold over 30% in the company and have the right to access certain documents. The directors are responsible for keeping these up to date. It's also the directors that it will be responsible if you have a problem with the ATO or a compliance issue, and then and upon looking further, your records weren't kept up to date for whatever reason, directors can be held liable for that. So it's really important. Even if you've got one director that maybe is a bit more financial than the other directors, it's still everyone's responsibility to make sure that that director is preparing the financial reports and keeping records, and everyone is accountable for that. So in terms of the financial records that need to be kept up to date, they need to correctly record and explain the company's transactions. They need to outline the company's financial position and performance. So that includes all your financial records, invoicing, receipts, any other financial documents. And this is really important as well. If the financial record would need to be kept for at least 7 years after the transactions and the records are complete. So again, using that example of maybe there's one director that's a bit more financially savvy than the other directors, if they are, preparing most of the financial records with the oversight and approval of the rest of the board, making sure that it's stored somewhere where it's safe and accessible for everyone. You don't want to be relying on one person or not having a good system or record keeping system where if that person was to leave or for whatever reason, that you no longer had a clear record for the next 7 years. If you are to get into trouble during the forward-facing 7 years, and again, perhaps you're under investigation or you're in court and you need to prepare a document, if you don't have access to that document, then you are going to be in breach of your duty. So it's really important that you've got that system set up. And there as well is that even if your records are held by someone else, which a lot of you may have accountants that are assisting you with that, company directors are still ultimately responsible for providing copies to any auditors or anyone entitled to inspect your records. So just because you're paying or engaged an accountant doesn't mean that you're no longer responsible. The ultimate oversight and storage and record keeping and compliance is over to you as a director. So these are some more of examples of the key Corporations Act sections that affect director duties, which I encourage you to be familiar with. I know these off by heart, and if you are a director or thinking of being a director, then you absolutely should as well. And it's something that, like I said before, should be at the forefront of your mind. It's duty of good faith and interest in the company, not improperly using your position or information, and importantly, prevent insolvent trading. So that's why we have protections such as in your constitutional shareholders agreement requiring that if a large transaction is to take place or a large investment, that it's a board decision that everyone or a certain threshold approve. It's up to everyone to ensure that you're not biting off more than you can chew. And if you are found to be insolvent trading, there can be significant consequences for that personally as well. Got a duty to disclose all material personal interests to the companies. So that's my reference before, one of the examples of, hey, I'm thinking of setting up another company or engaging in this advisory role. Your duty to maintain proper books and records, like we've just been through, and your duties at common law and in equity. We've got a couple of example cases here, and I guess the most important thing is to think about the real life examples in your business and how it might affect you. So in this case here with Adler, this was about acting in the best interest of the company and not using your position to gain an advantage, especially one that might cause detriment to the corporation. So this is, on a smaller scale. On a larger scale, this is, stealing company records or trade secrets and then contacting company clients and setting up your own business. That's pretty clear cut that is improper and in breach of duties. That's absolutely using company information and acting improperly so that you can have a personal advantage. But also thinking on a smaller scale, such as the example I gave before, is that maybe, and this is something that I've had a client go through recently, is that she had an idea. She was on the board of directors and she had an idea for the growth of the company, and the rest of the directors weren't really interested in hearing it. They didn't think it was a good idea. She thought it was an awesome idea. She was frustrated with the structure. She wasn't happy with the business. She decided that she was going to resign and she was going to go and set up her own company with that idea. Whilst that idea was not something that business was operating in, she had used her position as director to, an example you might use is, but not for her role as a director as that company, she wouldn't have had access to the information or the particular pain points that their clientele were finding, so that she could come up with this idea and then leave and set up her own company. especially if it would be a business that might mean that that company could no longer pursue that idea if they were interested, or maybe it competes with that company. So it's not just the kind of cases that you see in the news. It can be a lot smaller scale as well. So this one as well is just reiterating that you cannot abuse your power. You must avoid conflict between personal interests and those of the company. You cannot misappropriate the company's assets for yourself. And the shareholders, this is an important thing to consider as well, is that if impending insolvency as well, the shareholders have that protection, is that they will, if there's an asset sale or, the company is insolvent and shutting down, the creditors or the bank, the ATO, or the shareholders as well are all owed money out of that. And if the directors are found that perhaps they traded insolvent or they acted in breach of their responsibilities and duties, the company doesn't have any money left now for all of those creditors and shareholders to sue the company. The company's becoming insolvent. So if anyone that's lost a large amount of money, the first thing they're going to think about is, did the directors breach their duties? And then in which case we are going to claim personally with the directors for their breach of their duties in a hope to recover some of their funds. And this is in the Chew case here. This is an example of even if you are trying to use information or something that you've gained insight with in your role as director for your own advantage, even if it was unable to eventuate. So perhaps the company were aware what you were doing and they applied for an injunction, or maybe for whatever reason it didn't go ahead, you can still be held liable for that, even though it didn't eventuate into the intention. In this other case here, an example of not adequately disclosing their interest acts improperly. So keeping at the forefront of your mind that if you're not sure whether something should be brought up with the board or disclosed, maybe if it's you for the sake of just to be clear and sure, maybe you bring it up in a board meeting and everyone says, oh, that doesn't matter, but it's minuted, signed off. Or maybe you seek independent legal advice and ask whether the lawyer that is advising you thinks that you need to make a disclosure on the conflict or perceived conflict or personal interest that may need to be disclosed. And this as well, in this case here, it was to do with you cannot discharge your director duties, and that what that means is that you cannot, in that example of hiring an accountant, ultimately you can't blame the accountant if they weren't keeping your books up to scratch. Maybe you can as a separate issue, but ASIC or the ATO or whoever the auditor might be, they're going to be holding the directors liable for that. This one as well is sort of touching on confidential information. And just keeping in mind as well that the definition of confidential information is wide in terms of the Corporations Act. So there's a number of things to consider when dealing with confidential information. Shareholders agreements and constitutions and engagement agreements might have a definition of what they mean by confidential information. And sometimes they're poorly drafted and it feels like it might be a little bit of a loophole. But that loophole doesn't get you out of your obligations with the Corporations Act. So that's any information that you have learnt in your role as part of the business, and that would be expected to stay confidential. Perfect. I've already alluded to a couple of these as well about what can be done if you breach your director duties. But the examples we've listed here is that a member can bring action on behalf of the company. So that's a shareholder. Remember that as a director, you're acting for the company and the shareholders who own the company. So if they believe that you are acting in your own interests or putting the company at risk to become insolvent, then a member, either together or individually, can bring action on behalf of the company. Where the company has conducted itself in a manner that is contrary to the interests of the members as a whole, that can also, my example is that they can come make a claim together or separately. In those situations, members can seek declarations and orders from the court for the transfer of shares and the removal and appointment of directors and the winding up of companies. So there's a wide range of authority here, as well as, and importantly, seeking damages and seeking damages against the directors. So this is not like when you're a shareholder of a company where you have limited liability. As a director of the company, you can be held personally liable, and a range of different members or directors of the company can bring action against you and seek damages against you as a director. Perfect. So final takeaways, and like Joel said, we'll be sharing this PowerPoint with you and you'll be able to access the recording on YouTube. But I think definitely we've got a lot of information on these slides, so definitely download, take a look, read, digest. But our key takeaways today is understanding your legal duties and keeping in mind that it's not just business etiquette or what's encouraged, it are your legal requirements. Keeping your documentation up to date. So maybe after this call, you do an audit of, oh God, we haven't been making any financial records, or maybe we've got outdated contracts, or maybe we don't have a shareholders agreement and a constitution. All of this could lead to non-compliance issues. So doing a bit of an audit, we can help you with that as well. So if it feels overwhelming, get in touch with us and we can sort of go through an audit together and figure out if you've got any risks or what your priorities might be in terms of getting your documentation up to scratch. Don't rely on set and forget. So maybe you engaged a lawyer 2 or 5 years ago and you think that might be tickety-boo from now. The law changes. It's our responsibility as lawyers to keep up with recent cases and recent changes in legislation. So we'll let you know whether you need to update those documents, as what you had previously may no longer be compliant today. And keeping up, maybe you set a reminder every 12 months to sit down and do that audit and review your governance, your documents, and stay proactive. So as we've mentioned here, you don't have to do it alone. It can be overwhelming, and we can absolutely help you with that, whether it's jumping on a call and having an audit of your documentation, identifying the risks. Lawpath has legal templates on our subscription as well, setting up, reminders and expert support about when you might need to look at updating a particular document or a new law that might be applicable to your business. So yeah, as we mentioned there, our contracts and templates update instantly with the change of any law or any new information, and we will also notify you when laws change as well. Perfect. And how Lawpath can help. I'll just see whether Joel is here.
Certainly am.
Perfect.
Molly, thank you so much for that. Thank you so much for your guidance and wisdom. Guys, we still have Molly for another 20 minutes. So please go ahead. If any questions have come up, chuck them in the Q&A and we will get those sorted for you before 1 o'clock, hopefully. Now, moving forward on how Lawpath can help. Just a bit of a recap on why today's session matters. Directors are not just figureheads. You carry both opportunity and responsibility. By law, directors must ensure the company pays its debts on time, keeps accurate and up-to-date financial records, act honestly and in the best interest of the company, and avoid using their position for personal gain. And here's the truth. Failing to meet these obligations isn't just bad governance. It can mean personal liability, financial penalties, and serious reputational damage. This is where Lawpath platform and plans can become an essential for directors. So let's break it down real quick. I will break this down in our 4 main plans so you guys have better oversight if someone is new. Our first plan is the Essentials Advice Plan, and this is what it is. It's essential. It's your document library from Lawpath, created and developed and filtered through our legal team. As a director, one of the primary obligations is to ensure your company keeps proper legal documentation and contracts. So with the Essentials Plan, you get over 540 customizable legal HR business documents, anything from commercial, employment, HR, debt recovery, property, NDAs, IP, shareholders, trusts, whatever document you need. Hell, we've got wills if you need one. They're all pre-written and templated. So all you would essentially need to do as a director of a business is go, right, I need to make some contracts. I I don't know where to begin. I don't want to put too much effort into it. So what can I do? You can take one of our templates, change the name, date, time, a couple of phrases or clauses here or there, and there you have your document. Now, realistically, guys, contractual law is not rocket science. You're not dumber than the lawyer in any way. You know your business and you know what you need to have within this contract. But it is helpful to have someone there to support you throughout the entire process of identifying what contracts you need, what should go into it, and so there's no contradicting information, or if you put something that's actually not supposed to be there, and then obviously the review afterwards. So you have your essentials library, which is $468 per year. We've split the two because some people don't necessarily need legal advice, or we actually have a lot of lawyers and accountants using this plan, the essentials plan, autonomously. So if you feel like you love this stuff, you love going through contracts, you love educating yourself, you can use this plan by itself. You won't necessarily need a lawyer to help you if you feel confident with what's going in within it and what you're distributing out to the populace. It also comes with the e-sign feature as well. So if you have clients in different states or overseas, for example, that are adhering to Australian law, or if you have employees coming on and you wish for them to sign beforehand, the e-sign feature is wonderful. That's your essentials plan, $468 per year. Adjacent to that is the legal advice plan, the older brother. So again, if you're new to running a business, or if you're moving in, if you're filling as a director for a friendly business until they can substitute someone in, and you sit there and you go, oh God, you don't have your contracts in place, or you have your employee handbooks out, or the shareholders are at each other's throats. We need to figure something out. This is where you can benefit from the legal advice. We can take away a lot of that friction for you, so you can just focus on the business itself. And by friction, I mean working on contracts with you, helping you identify any risks that your business might be moving into. If you're branching out, if you're rebranding the business, if you're going to be creating a website or taking on employees or taking on a bigger tender, or maybe even considering investors, you want to make sure that you're doing everything right. Because what is the point of pumping all this money into an entity, something that is a passion project for you, if you're not going to take the right measurements and steps for that success? So with the legal advice plan, you get unlimited 30-minute calls from Monday to Friday for 12 months. So if you wanted to speak to the lawyer at the start of every week, at the end of every week, or consistently throughout the week, you can. And you can choose the same lawyer from our team, so you don't have to speak to someone new and have to, give your whole life story again and what you're going through. You can just have the same lawyer, same time, every day for 30 minutes. Molly, for example, you can choose Molly. If you are in Victoria and you prefer someone who's a bit homegrown. And yeah, it's almost impossible, guys, to have unlimited 30-minute calls with the client, with a lawyer or an accountant from our team every day, and them not to have a great relationship with you, and them not to understand your business and know it as good as they know, how to make a sandwich. So legal advice plan is $1,668 per year. Now, if you wanted to combine our legal documents and the legal advice plan, we have a thing called bundling, and all this can be found on our page. You can put the two plans together, and we put 40% off on top of that. So the essentials and legal advice plan would come to $1,708. So essentially, you're adding the document library on for about $60. That would be one of the strongest pillars that you will ever have for being a director. Now, the other two pillars that we have is our accounting and tax plans. Now, with the accounting advice plan, not to be mistaken in conjunction with tax, we have two separate ones. That is where you get partnered with a senior chartered accountant. And it's pretty much the exact same premise as a legal advice plan. $1,668 per year, unlimited 30-minute calls. On this plan, we will teach you how to do all your own bookkeeping, your own payroll, your own invoicing. We will help you with your GST advice, how to pay yourself as a director, how to qualify and claim items underneath the business as well, vehicles, tools, machinery, whatever it may be. This plan is especially helpful, and most of our plans are helpful for people who are working from home, who are, have their own personal business at home, and you don't necessarily have time or the patience to go out into an office and speak to a lawyer and accountant. You can just have all these calls with the click of a button at home. So on the accounting advice plan, if you are planning to do your own bookkeeping at least in the first 1 to 3 years, or you feel like your accountant isn't giving you enough attention, they're not relaying enough information to you, so you feel like you're forced to come on and spend an hour with us on a webinar to get greater education. If you're spending too much money for simple services, at least with these plans, you've paid out for a whole year. It's only $1,600, and then you can have ongoing calls for 30 minutes whenever you want. And we are big business related accounting. So we're not just going to give you general information. It is going to be thorough, in-depth conversations in relation to where your business is going, how well it's done in the past, and where things are moving forward. We can give you that greater oversight. And then finally is our last plan, the grandfather of plans, our tax plan. So with the tax plan, there's no DIY. We will literally just do all your BAS, tax, and the financial reporting, everything for you. Just like the accounting advice plan, we also provide tax strategies with this as well. So we can have greater looks, more in-depth looks at how the business has been running from day one to now, where things can improve, where you can reduce the amount of taxes you're paying, and then we can also educate you on greater tax incentives and things like that too. If you were interested in getting all this juicy package, we do have our bundle services where you can get essential legal, accounting, and tax in one hit. So instead of you having a lawyer here and an accountant there and getting your document library from here, it can all be in one spot. And I'm sure if you've had experience with lawyers and accountants and tax agents before, if you make comparisons to our prices, we are pretty competitive. So if anyone is interested in learning a little bit more about how these plans work in conjunction with your business, you can go ahead and put yes into the chat, and I would be more than happy to take your name down and reach out to you. And if you wanted to have it can just be a general chat. If you just want to have a general chat, if you're not ready to spend any money because capital's not up there at the moment, we can talk about potentially scheduling an appointment with you later on down the track as well. That is everything. For those who did come late, we did have, I did mention that we will be sending an email out with the slides, the YouTube link for today's webinar, as well as information on Molly, all of our lawyers, discounts, et cetera, et cetera. As you can see on the screen here, if anyone is interested in our legal advice and anyone's potentially interested in having Molly as their lawyer, for example, if you like the way Molly conveyed the information today, that code there, LAP Web 20, all you need to do is go into products and pricing on your Lawpath profile, go to the legal advice plan, you put that code into the coupon code, and you will get a 20% off reduction as well. Now, without further ado, if you guys have any burning questions, go ahead and chuck them in the Q&A and we can have Molly take care of these for you now. Thank you, Molly.
Thanks, Joel. Cool. I'm just catching up on the chat to see if there were any questions in here. Amir, I see that you're needing to prepare your company for what Amir said is, I need help in preparing my company ready for potential investors, and can you help in finding potential investors? Absolutely. It's good that you're thinking ahead. Is that there in terms of preparation for investment? It's absolutely something we can help with in one of my specialty areas as well. And it's often, there can be a bit of a process that's involved with each different item. So getting an idea early about, doing that audit about what might be required and making sure that there's nothing, whether it's compliance or a contract or anything annoying getting in the way or delaying or even stopping investment at that time that you're ready. And we can also let you know the sort of whether letting you know, we keep an eye out if there's pitch events coming up that might be helpful, or different connections or events that you might be able to go to start sort of deciding what your profile might be for what the right investor is for you. But Amir, I definitely recommend reaching out to us if you'd like to have a further conversation about how to prepare you for investment. Think that, and Justine is wondering, do we provide advice on different licenses and ways to structure partnerships? We absolutely do. That is absolutely something we can help you with. So maybe, Justine, if you wanted to reach out to us after this call, then we can connect you with the right person and what the right way might be for your specific situation. Perfect. Mark here is wondering, in a startup phase, year 1 and 2, what constitutes sound governance for a sole director, also sole shareholder and employee consulting business that has employees, an external accountant, and is growing? Okay, Mark, I think as a starting point about considering whether you, whilst it's just yourself, and of course is that little bit easier and that there's no other sort of people that you need to be running decisions past, but not letting the governance go by the wayside just because it is you. So for example, getting ready for if you are going to bring on other. Sounds like because you're startup phase that the plan is to grow. So starting to think about getting a constitution in place if you haven't already, thinking about how whether certain decisions you might make a memo and sign yourself as well as a resolution. Making sure that if you're paying yourself as an employee, making sure that you've got an employee contract and engage correctly that way. And really, I think while you're at this year 1 and 2, while it's just you, I encourage you to really consider about the different hats you're wearing as an employee, a director, and a shareholder, just so that as you start to grow, those roles aren't confused and mixed, and that you understand all of the different roles that you have in each capacity. But absolutely, Mark, reach out to us if you wanted to have a further chat about that. Wonderful. I think that might be all our questions.
We've got a couple of questions in the Q&A.
Oh,
If you wanted
okay.
to, can you see those there, Molly?
Perhaps if you want to
Yeah, I can read them out to you. Yeah. So Ali Malik has asked, how often do we need to report our records to ASIC?
So your ethic, in terms of your actual reporting, it's a lot of this is to be keeping internal, it's internal records. And then if anything was to go wrong or you were to get audited, then it would be expected that you had those. So staying in the practice and keeping your internal records. In terms of your annual reporting obligations with ASIC, well, first of all, you've got 28 days to update ASIC if there's any change in your company structure, you issue shares, a shareholder leaves, a director changes their address. You've got 28 days to notify ASIC, otherwise significant penalties can apply. And then also you receive an annual report from ASIC each year where you need to pay your annual renewal fee. A lot of people receive that report and they pay the annual renewal fee without giving it much notice. But that's actually another opportunity to review your company details and make sure everything's correct. If it's found later that there was something that wasn't updated, which often is lawyers coming in at perhaps a little bit later than would have been needed, finding that there was some mistakes in earlier reporting, continue to pay the annual ASIC fee where they had the opportunity to see the mistake, and then those penalties can be huge.
Perfect. I realize most of the Q&A questions were already in the chat, so you have gone and addressed all those already. I think, who else do we have here? Adele Johnson has asked, can you advise us to what stage you might change from a sole trader to a P2A Ltd with a sole director?
That is a big conversation. I think that it's definitely the main thing I would be thinking about as well is that when you become a sole director shareholder company, you have limited liability as a shareholder, whereas a sole trader does not have that protection. So just consider whether you're in a business that carries inherent risk, or maybe people are relying on your advice and then they could sue you if something was to go wrong, or you're in any sort of risk industry where there could be risk for you. I would recommend considering going into a proprietary limited. I think if you want to have a follow-up chat after this, feel free to reach out to us and we can go through sort of what the main benefits and risks would be for you transitioning into that structure, or when might be a good time.
Perfect, Molly. I dare say that's everything. Was there any final questions, guys? Thank you so much, Mark, Anil, and Adele, for the questions.
Wonderful.
Perfect. I'd say that's it, but yeah. Peter Stanton. What is the best way to resign as a director?
This will depend. We've got all of the templates on the Lawpath platform if you're already signed up to Lawpath. Otherwise, if you're not, there's a number of documents. For example, you need to resign formally. So, and there also is likely to be a resolution after that as well. And then ASIC will need to be updated. but it's really important about your specific company constitution and maybe shareholders agreement as well, about following the process that's set out there. So I'd recommend probably for that one, have a look at your constitutional shareholders agreement if you have them, but otherwise I would recommend speaking to a lawyer about that as well.
Beautiful. Everybody, thank you all so much for attending today. We really, really appreciate your time. 1 hour out of a busy entrepreneur's day is not easy. So again, we really, really are honored to have you all here. Molly, thank you so much for stepping in for Mark at this stage and being so open and just having so much knowledge and guidance and wisdom. We really appreciate it. And yeah, look, if anyone is interested in I guess having a conversation with me later on. I've got the names of those who are interested, but if anyone else liked today's session and likes the way Molly conveys information, keep in mind she is an available lawyer, so you could have her helping you and representing your business moving forward. That should be everything. I will go ahead and send that email out shortly to you all. And thank you so much for attending today's webinar. Thanks again, Molly.
Thanks, everyone.